This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why insurance companies now exclude diminution of value of vehicles after an accident, and why an insured's public policy argument failed because of a lack of evidence of statutes or judicial statements creating evidence of a public policy. Following a car accident, Kenan Watkins filed a diminished value claim with his insurer, Allstate Property and Casualty Insurance Company. Allstate denied his claim. The district court held that Allstate's policy did not violate Mississippi law, and what Watkins failed to state a plausible claim. Consequently, the district court granted Allstate's motion to dismiss and Watkins appealed. In a case called Kenan Watkins, individually and on behalf of all others similarly situated versus Allstate, the United States Court of Appeal for the Fifth Circuit on January 12, 2024, resolved the dispute. The facts upon which the claim was made started with the fact that Kimberly Jones crashed her vehicle into Watkins' 2021 Chevrolet Tahoe in Baldwyn, Mississippi. Watkins' vehicle sustained substantial damage. Watkins had an insurance policy with Allstate that provided coverage for his Tahoe. Jones's insurer, Safeway, paid $24,314.25 to Watkins for his damage claim. Watkins alleged that his car sustained an additional $13,545 in diminished value. Safeway offered the remaining $685.75 of Jones's policy limit to Watkins, and because Jones's policy limit did not cover the diminished value of Watkins' vehicle, Watkins filed an uninsured motorist claim with his insurer, Allstate. Allstate denied Watkins' diminished value claim, relying upon a provision in its policy that excludes, quote, any decrease in the property's value, however measured, resulting from the loss and or repair or replacement, close quote. Watkins, unhappy, sued. Specifically, Watkins alleged that Allstate's automobile insurance policies impermissibly deny insurance coverage that is required by law without establishing which law required Allstate to pay for the diminished value of his truck. The district court concluded that Watkins failed to plausibly allege that Jones's vehicle was an uninsured motor vehicle, and also concluded that Allstate's diminished value exclusion was valid under Mississippi law. Because Watkins failed to state a claim upon which relief could be granted, the district court granted Allstate's motion to dismiss with prejudice. Of course, an appeal followed, and that's why we're in the Fifth Circuit. In his complaint, Watkins alleged that pursuant to Mississippi Code Section 83-11-101, close paren, Kimberly Jones was underinsured and that he is entitled to recover from the uninsured motorist coverage provided by the policy. Watkins' mere assertions, however, were insufficient to establish that Jones's vehicle qualified as an uninsured motor vehicle. The complaint only alleged that Jones was underinsured, which is a legal conclusion. No court will accept legal conclusions as true. Thus, the district court correctly concluded that Watkins failed to make a plausible claim for relief because a reasonable inference that Allstate was liable for misconduct could not be drawn from the factual content in the complaint, and legal conclusions alone are never accepted as true. the Fifth Circuit concluded that Allstate's diminished value exclusion was valid under Mississippi law. Watkins' claim that the diminished value exclusion violated public policy failed because Watkins did not point to a pronouncement, either legislative or judicial, requiring the diminished value to be part of all automobile insurance policies. Only an affirmative expression of an overriding public policy by the legislature or judiciary prompts a court to rule that an insurance policy's plain meaning does not control. Since neither the legislature nor the judiciary have pronounced that insurers must provide payment of diminished value in all issued automobile policies, the plain meaning of Allstate's policy controls, and Allstate's diminished value exclusion is valid under Mississippi law. In my opinion, claims for diminished value of a vehicle after an accident were popular 10 years ago because auto material damage policies did not deal with the issue. They didn't even think anyone would ask for it. When it happened, insurers like Allstate recognized it had no intent to cover diminished value of a vehicle after an accident, did not charge a premium for paying for such charges and for such a claim, and eventually wrote a clear and unambiguous exclusion to avoid paying for a loss for which it had not charged a premium. Absent some showing of public policy requiring that coverage, the exclusion was clearly enforceable. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe for free to the videos on YouTube or on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. If you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.